We're here today to talk about opening statements. Separate from this video, you have a demonstration video of an opening statement done by Daryl Hawthorne Seawright, a member of our trial team who does an opening statement for you, and alongside of that you see the proper structure for opening statements. So you'll want to watch that video as well as this one. In this video on opening statements, we're going to cover how you write the speeches, how you do it, appropriate speech structure, and what to do and what not to do. Essentially, we're trying to cover the things that hopefully you want to learn. That is specifically, how do I write this thing? And how do I win my case with it, right? The way you win your case with it is by being persuasive. And we'll talk about the best ways to be persuasive when delivering the speech as well. To persuade, the jury has to understand your speech, they have to believe you, and they have to like you. So let's start first with understanding the speech. Why is an opening statement so important? Well, you know all about the case. It's something you've lived with, you've worked with, you've read every scrap of paper, you've thought about your case theory, you've thought about the evidence to try to figure out what's coming in and what's not coming in. But the jury doesn't know anything about it. This is your first opportunity to persuade them. And we know, science tells us that jurors fit things into what's called a story paradigm. That is, most jurors will decide upon a story that makes sense and fit the evidence that comes in afterwards, either in that story, if it makes sense and fits in the story paradigm, or they'll discard it if it doesn't align with their belief system. And this is your opportunity to plant that seed, to begin that story, to explain to them in an uninterrupted way what the case is about and why you should win. When you're doing a direct or cross-examination, when you're putting in evidence, by its nature, that gets interrupted, right? It's a conversation back and forth or a questioning of a witness. There may be objections. In opening statements, there are typically very few objections. You have an opportunity to lay it out for them, to explain why you should win and do it in a way that persuades and grips them. So how do you do it? How do you write a story that they're going to understand to be persuasive? This is the structure we recommend. This is the structure that you'll see Daryl using in the demonstration. It builds in, you've heard us talking about primacy and recency. The principles of persuasion, there's actually three of them: primacy, recency, and repetition. This structure builds that in. You begin with an attention-grabbing paragraph. That is something that grips their attention, a paragraph that has a theme in it. After that, you give them a paragraph where you introduce yourself, introduce your client, give them just a snippet of why you're there. Generally, the speech itself will be organized topically around 2 or 3 points. At the end, you repeat what those points are, and you end with a strong call to justice ending, something that shows to the jury that truth and justice are on your side, and that the correct way, the just way, the fair way for them to give a verdict is to give the verdict that you're asking for. Let me pause for a moment and talk about that organizational structure in the middle there, the 2 or 3 points. There are lots of different ways to organize a speech. You'll see some lawyers organize a speech chronologically. That is strictly starting at the beginning, moving through action in time until the end. Sometimes lawyers will organize a speech witness by witness. This is what Ann Halen will tell you. This is what Officer Roth will tell you. This is what Officer Osborne will tell you. Some speeches get organized around, say, the elements of the offense, right? We have to prove A, B, and C. Here's how we've proved A, B, and C. We find none of those structures as compelling as the point organization. Now, points allow you some flexibility. Points are topics, right? These are essentially 2 or 3 topics that are headlines. They're essentially headlines under which you organize information that show that you win. It gives you some greater flexibility than either sticking with a straight chronology or witness by witness. And frankly, elements of the offense end up, honestly, to be usually a little boring. But the point structure, the topic structure gives you some flexibility. Let's start by talking about that attention-grabbing paragraph. It's your first opportunity to either frame the case, if you get to go first as the prosecution, or to reframe the case if you're going second as the defense. So you want to connect with the jury. You want them to understand by the end of that paragraph a little bit about what your case theory is, what the case is about, and why you should win. That first paragraph should be pretty short, no longer than 4 or 5 sentences, but it should give the jury enough of a picture that they understand your theory of the case at the end. And that paragraph in its either first sentence or its last sentence should have a theme. So what's a theme? Well, a theme is different than case theory. A case theory is a description of why you win, right? It's usually a sentence or two saying, all right, this is overall, in general, what we think happened. A theme is different. A theme is something that catches attention. A theme is a word or a commonly used phrase. Sometimes it's a quote from something someone said in the case, but it's something that sticks with them. It's something that's memorable. Themes should be the same in opening and closing, and the theme should ideally be repeated both in the beginning, towards the beginning of the speech, the end of the speech, and at some point during the trial as well. So when I say it should be something catchy, think, in a products liability case, the theme of putting profits over people, right? That's catchy. Or that infamous theme from the O.J. Simpson case, if it does not fit, you must acquit, right? Memorable, catchy, something that sticks with them. That's clearly not case theory, right? If it does not fit, you must acquit is not comprehensive enough to be a case theory, but it's the thing that sticks with them. So themes are important, and themes should show up in that first paragraph and again towards the end of your case. So in the case that you'll watch in the demonstration opening there, Daryl's theme is talking about the natural human emotion to want to make someone else pay for what happened. Larker versus Sunshine, you'll see Daryl has, I think, probably the harder side of the case. She's doing the opening for the defense. In that case, a young woman goes down to a hotel for senior week. She's underage, she drinks, she is sexually assaulted by some young men, and eventually is suing the hotel owner for permitting underage drinking in the hotel. So there's some natural emotional sympathy with the plaintiff's case there. It's harder to come up with a case theory and a theme for the defense case, and it's the defense opening that you see. I'll note there, for those for whom sexual assault is a triggering event, there is not a graphic description of sexual assault in it, but it is an issue in the case. So if that's a thing that you're concerned about, you might want to skip the demo. That is what the case, though, is about. So after that attention-grabbing paragraph, there's what we call an introductory paragraph in the opening. That may seem strange because it's not the first paragraph, right? It's the second paragraph there. Why are we calling it an introductory paragraph? Well, because in that paragraph, you are introducing yourself, you're introducing your client, you're explaining why you're there or why you're not there, right? The explaining why you're there and why you're not there is a nice moment where, if you're the prosecution, you're talking about the charges, right? So that the jury has that up front. They know what the charges are. Or if you're on the defense side, it allows you to have a denial up front, right? To say, look, James Page isn't here because he robbed anyone. He's here because of this misidentification or whatever your theory is there. Gives you an opportunity to say that up front. We want to talk very briefly about the burden of proof. If you're the prosecution and the burden of proof is yours, you want to welcome that and say that that's not something you're worried about because you're going to meet that burden of proof. And on the defense side, you want to make sure that the jury knows from the outset that you don't have to prove anything. It's the prosecution who has to prove their case. At the end of that paragraph, you're talking about your points, those topical points, that structure that's going to frame the remainder of the speech, right? That you know that James Page is guilty for 3 reasons. 1, 2, 3. Or, you know, that the jury will know by the end of the case that James Page is not guilty for 2 reasons, 1 and 2, and list them out there. For the repetition to work well in the point system, you want to be naming the points specifically, right? You talk about point 1, you see Daryl's point there, you talk about point 2, and then you transition to the first point. And when you transition to the first point, you use that same language again to talk about it, right? So it would be, they will not be able to do that because we will show, 1, Mr. Gibbons acted reasonably and responsibly as a hotel owner, and 2, Kathy Larker's own poor judgment was negligent and unreasonable. Let me talk about that first point, that Mr. Gibbons acted reasonably and responsibly as a hotel owner. It's going to sound clunky to you the first time you do it, but it's that repetition of the exact same language of the points up front and then the points within the body of the speech, which builds in both repetition and signposting. What do I mean by repetition and signposting? Well, the repetition part is obvious, right? You're essentially telling them what you're going to say and then saying it, laying it out. And then again at the end, repeating the points a 3rd time so that they sink in. Here's what I mean by signposting. When the jury hears you transition to point 2 or that 3rd point, right, with a, well, that brings me to my 3rd and final point, that, you know, using whatever that is, using the same language. They know where you are in the speech. They know that the speech isn't meandering and going to go on forever. It actually helps them pay attention. The signposting lets them know, okay, we're at that 2nd point, we're about halfway through. Oh, we're at the 3rd point, we're wrapping up. So the signposting and the repetition are also elements of persuasion to help the jury follow along. Okay, things to do, to make sure you do during the opening statement. We've talked a bunch about structure. That's how they'll understand the case. I mentioned here, focus on telling your story before talking about your opponent's case. It may be that you have a lot to say as to why the other side's case shouldn't be believed or isn't good. But if you have a story to tell, you should tell your affirmative story first before you knock down the other side. Otherwise, the speech comes off as too defensive. And the jury, you want the jury more focused and focused sooner on the affirmative good things you have to say. So always make sure you talk about your story before you knock down your opponent's. You've heard us talk about bad facts. If you have bad facts, you need to consider your opponent's perspective and put those bad facts in the best context you have. You'll see that in Daryl's demo. She has some really bad facts, some facts that will naturally make the jury feel very sympathetic for Kathy Larker, and they should. She contextualizes those bad facts by acknowledging that, right? To say, hey, it's natural to feel sympathy for her. You will, you should, we do as lawyers. But to say, all right, you also have to, as jurors, look at the other evidence in the case. Always important to not ignore your bad facts. There may be moments when you want to tease for emphasis, to say, members of the jury, I want you to pay very close attention to who called the police in this case, right? So that they are looking for that later on, because that's an important fact here in the Larker case, that it's Frank Gibbons, the defendant, who called the police in this case. You always want to be deliberate about word choice. Speak simply, talk like a person, no 50-cent words. You always want to speak simply and directly to the jury. I mentioned at the outset, we're going to talk about how to persuade, right? We said that to persuade, they need to understand what you're talking about. They need to believe what you're talking about, and they need to like you. The understand what you're talking about comes from that structure. The believing what you're talking about comes from a case theory that is logical and makes sense, right? And you've seen our videos on case theory. But how do you get them to like you? The last piece of that, right? There's two elements about that I would recommend. One is they have to see who you are as a person. If you are reading the speech from off of a paper and not making any eye contact, right? If I'm doing this lecture and the entire time I'm reading from something here, there's no connection. You need to get your eyes off the paper. And that may mean just reading the speech you've written aloud 2 or 3 times before you give it in class. If you do that, you will be less tied to the paper and be able to make some eye contact and just talk to the jurors. The second element of that is allowing some of your personality to show through, and some of your passion to come out. If the jurors believe that you, as an advocate, believe your side is the just side and the side that should win, and if they get to see a little bit of your personality and who you are as an individual, they're much more likely to connect with you and to like you, and accordingly to be persuaded by you, right? Daryl had a very tough side of the Larker case, but she still felt like she believed that her guy was the person who was right in this, and part of that passion and that connection helps make you more persuasive. Some things to not do in an opening statement. In an opening statement, you're not allowed to argue. That is, you're not allowed to tell the jury what conclusions to reach from the evidence. You can only lay out what the evidence will be. Do that in a way where you're really telling a story to them, giving them a narrative, but you can't argue. Means no rhetorical questions, no asking them to draw conclusions, no telling them what the evidence means. You don't want to repeat the phrase "the evidence will show" a lot. Maybe you heard that one time in Daryl's speech, right? You might have that early on once in the speech, but after that, it's really filler language, and it's language you don't need. It gets in the way of the storytelling. Just talk about the facts. Just talk about the things that are coming in. Beyond mentioning burden of proof, you're probably not talking much about law in an opening statement. Unless in a criminal case, if your client isn't testifying, you might talk about the fact that your client does not have to testify, that he's presumed innocent. But really, save the law stuff for closing argument. I note here not to give them a whole civics lessons. For those of you who've done any work at the Criminal Justice Center, you may have seen some of the old-time lawyers talking about civic duty and how important it is and thanking them for being here. All of that, frankly, is wasted time. The jurors want to know what this case is about. They want to know who you are as a lawyer and why either your person did it or didn't do it. They want to hear about this case. So don't waste your time on civics lessons or crazy stories that have nothing to do with a case. A few other things to avoid. You don't want to call your story a story, or claim that anything you're talking about isn't evidence and that the jury should not pay attention to it, right? Just get to the meat of the thing and talk about that. We've talked about structure here. Those middle two, making a promise you can't keep and overstating evidence, are related. We mentioned that to persuade, the jury has to believe you. Part of that is only essentially making promises that you can keep in the opening. If you are too detailed, or if you are talking about facts that aren't going to come in either because your witness won't actually say them, or because you're talking about facts that are going to get excluded because of an evidentiary ruling, you lose credibility with the jury. And I'm sure you can count on your opponent calling you on it in closing argument, right? Mr. Epstein promised that you would hear about bags of groceries being in front of Leslie Plant when she walked up the stairs. Did you hear anything about that? Right? So don't make promises you can't keep. Opening statements are usually much more general than closing arguments because on some level you're worried about that. And presenting immaterial details relates to that too, right? The more general you are, the less you have to worry about overstating evidence or promises you can't keep. Now, you still have to give them a comprehensive narrative. There has to be enough in there that they can follow from point A to point B, but should not be overly detailed and should not be too long. Opening statements are generally not as long as closing arguments. You know, for this assignment, given the case you have, 5 minutes to 7 minutes is probably about as long as you want this to be. In the end, you want to loop back, right? After you've gotten through point 1 and all the substance in there, all the facts that should come under that, point 2 and all the facts that should come under that. At the end, you're repeating what those 2 points were, or 3 points were. You want to mention your theme again, and you want to leave the jurors thinking that the only just thing, fair thing to do is what you're asking them to do. You know, at the end of an opening, you should be mentioning the verdict you want, but they don't have the facts yet. You can't be demanding a verdict yet, but you can tell them that at the close of the case, you'll come back, and once they've heard the evidence, and once they know that the just thing to do is whatever you're asking them to do, and at that point you will ask them for, you know, whatever verdict it is you want, either a verdict of guilty or not guilty. So you want to be mentioning that as part of your ending there, your call to justice ending, but you're not in a position to demand a verdict yet because they haven't heard the case yet. I recommend the demonstration to you. You'll see alongside of it the steps, the structure steps Daryl hits as she's going through the speech. And good luck with your opening statements.